job in this economy. With no disrespect to anybody, but people would have you believe that the lawyers in the system are causing a problem. The reason that they're coming to me is because they can't get access to the benefits. And if as Frank Neuhauser's report showed, we're able to actually make some arguments and increase the benefits. It's as if we could make this a lot cheaper for insurance companies. We could deny lots of benefits and make it cheaper for everybody. That's not what the Constitution says, and that's not what your intent was when the laws were passed. These unintended consequences need to be addressed. With that preamble, Frank Neuhauser's report last February seemed to indicate that there was a 58% loss in permanent disability benefits, a drop. Today, his slide says 61%. So I can only assume that he's got some additional data that reflects that. In his last report in February, he indicated that if it wasn't for injured workers' lawyers, that number would be significantly higher. That 58% or 61%, that is against the RAND studies data from 2003 that showed that California's permanent disability schedule was only providing 37% of an injured worker's lost wages. And RAND determined that that was an inadequate amount. And so Mr. Neuhauser's numbers are showing that we're 61% below that number. And that was inadequate. And if we're here to talk about raising those benefits, are we talking about raising them to where they should be? Are we talking about raising them back to the 37%, which was inadequate in 2003? We've provided you with some materials. Angie raised the same issue, and it's on page 6 of this white paper that we produced. And this was produced by Mark Gerlach, the consultant for the California Applicants Attorneys Association. And on page 6, it reflects what Angie was saying. You heard testimony earlier today that seemed to reflect that for every dollar being paid, the carriers were having to spend $1.30 in benefits. That's not true at all. 84 cents is being paid in benefits. I'm reminded of what caused this system breakdown to begin with. As Commissioner Jones discussed earlier, I think we have a mismanagement of the money. If it's costing insurance companies 24% and 22% respectively to manage the cost of the claims, those are the frictional costs that need to be adjusted. And I believe that you've had various people talk about the medical provider networks, utilization review, the QME process. All of those frictional costs are contributing to these costs. Why are those costs there? Because I'm fighting for my families that I'm represented. And if we change the permanent disability schedule, if we change the FEC modifier that Andrea Hoke manipulated and came up with, if that FEC modifier more accurately reflected the lost earnings and provided for an accurate permanent disability, how much of those cost savings would there be? We wouldn't be fighting about some of these things if the permanent disability schedule was in fact accurate. If the people received an accurate permanent disability award at the end of their case, we wouldn't be taking the multiple depositions of the doctors and getting the supplemental reports from the doctors and fighting about all of these cases. That's contributing to the frictional costs and the increased money. And so if people seem to be saying, well, we have to figure out where the savings are, if we knew the adjustment we needed to make to the FEC modifier and what that would how that would change the permanent disability money chart, the schedule, then we can have an intelligent conversation about the fact that we wouldn't need all of the frictional costs. You can't assume that if we raise PD benefits that those frictional costs are going to stay the same. They won't. I'm fighting for the families that I represent. Just as I know it's important to get off of statistics and talk about people. And just sitting here today, I remembered a couple of cases that I had recently. I represented a Latina woman who had an ankle fusion and had very difficult time weight bearing and could hardly walk. And under the AMA guides, the doctor used a table that dealt with loss of range of motion because it was a fixed joint, and provided 3% under the guides. Do we know what that translates to? $5,000 for a woman who lost her job. Through my efforts, which required numerous years and changing doctors and depositions, we got it all the way up to a whopping 13% for a woman who lost her job. I had a recent case that I settled last week and a half ago. My client worked for the county. She had bilateral upper extremity problems. She had numerous elbow and upper extremity surgeries. The county worked with her, tried to provide her with modified job. Finally, it came to pass she had to lose her job. The strict AMA rating was 0%. Frank was talking about the zeros. Here's a woman that lost her job, had elbow surgeries, carpal tunnel surgeries, couldn't go back to a good job. She worked for the county. She had health insurance. She had a pension. A 0 rating under the AMA guides. Because she had me, right? I'm able to make arguments. I'm able to argue with the doctor. I'm able to argue with the defense lawyer. We settled the case for $24,500 total lump sum payment. That's not on an annual basis, right? And she's lost her job. She spent her career in that capacity. Now she can no longer do that work anymore. What's she supposed to do? To believe some of these people, well, that's okay. You know, average justice, that's okay. That works for us. These are families. Just to touch on some other issues. The Commission on Health, Safety, and Workers' Comp study talks about the QME process, and there are doctors. I'm only going to take a couple more minutes. There are doctors that seem to have figured out how to become the primary QMEs in the system. The studies seem to show that 3.9% of the QMEs conduct 40% of the evaluations. And not surprisingly, their ratings are substantially lower than other QMEs. The temporary disability is a large problem, and I applaud both houses. Last year, you passed the temporary disability bill that ultimately got vetoed. I believe that temporary disability bill would have provided increased temporary disability, the length of time that somebody can collect temporary disability. Should the injured worker need an additional surgery or need a surgery and needed time to recover from that? And of course, we know Governor Brown vetoed that. And so if we can figure out how to resurrect that, that would be helpful.
I authored that bill, so I'm aware, and yeah, maybe there's a role for that item here in this comprehensive package.
Yes. I mean, that's a perfect example of how there's been a cost shifting to the public. Those people that can no longer receive temporary disability past the 104 weeks are now collecting state disability. They're applying for Social Security disability, when in fact that should have been borne by the carrier and the employer. The reduction in the number of claims. The Senate Bill 899 didn't make it safer to work in California. Why was there a reduction in claims? The word on the street was, there are no more benefits. There's no sense in applying for workers' comp. Go get your benefits elsewhere. Use Medicare, use state disability. Good luck. It's only been now that we've been able to make some inroads. People are now realizing, oh, maybe if I hire a lawyer, maybe I can file a claim. So you have to be careful how this information is interpreted. I think earlier I heard somebody talk about some fraud and abuse. And I just need to say that employer misclassification and premium fraud is a much bigger problem than any injured worker taking too many pills would ever cost to the system. Nationally, it's a $50 billion problem. And I just want to make sure people realize that my client who's trying to recover from a surgery isn't the source of the fraud and the abuse. Employer misclassification, employee misclassification of employers, of employees, I'm misspeaking. The underground economy is contributing greatly to that. And with that, I'll take questions.
Thank you.
Thank you for that presentation. Thank you for what you do on behalf of injured workers. I think the reason that I personally am concerned about the numbers and insurance companies, it's not just insurance companies, right? It's also school districts and cities and other folks that are self-insured and companies. Because the data I'm seeing, and the panel before you, it just shows a growth in all sorts of benefit payments. So there is that going on. But I'm looking at your page 6 here. Even if you look at the pink graph, from 2006 to 2010, there is a more than doubling of the amount, in the pink that's being paid, right? In terms of percent of premium paid out for benefits. And even if you took one of the great years, let's say 2005 with the blue and yellow, and you just added those to the 84%, you still exceed 100%. And so the reason that I'm focused on this is because the governor's administration has had a stated goal that they don't want to increase employer costs. But we don't have to have that goal. I mean, if really the belief is we want to compensate injured workers at the rate they should be compensated, it may just be employers' costs are going to rise. I just want to be honest about it. I just want, if that's the case, then we have to say, we're going to do this, but keep in mind, because of every data point we're looking at, employer costs will rise, but that's a necessary, consequence of restoring to the level we want to restore it to, of the permanent disability and other benefits. Or we can go with the governor's goal, which is we're absolutely not going to raise employer costs, in which, in my mind, then there's, to me, the one-to-one relationship just, I don't know how mathematically it works. And so that's sort of what I'm just looking at, just based on the data. I'm open to other views and other data as well, but even at your own graph, we're exceeding 100%, just if you add in everything.
I would add to the fact that this graph does not reflect the amount of money the insurance company makes on investments. This is just the premium dollar.
Okay. No, thank you.
Mr. Liu, I want to piggyback here a little bit. I just want to be aware, because it's coming to a district, your district, each of yours now. Public agencies in your district are using reserve dollars from old years to pay for current year budget shortfalls. We're really in the birthing process of another unfunded liability. We're out of money for public agencies, a fifth of the marketplace right now. And so I just need to reemphasize that. If it's a one-to-one exchange within the system, I think we're even going to miss the mark there, because the trajectory of claims over time, not 12 months, not 24 months, but the length of time of that claim being open is going to eclipse the dollars. And so we don't have enough money in the system, and it's certainly not going to come from schools. So I just want to reiterate that a lot of our agencies in your districts are in a very, very precarious situation.
Mr. Chairs, if I may, that the system left untouched today, the trajectory is going up because of the inefficiencies in the system. If we did nothing today, if we did nothing on the injured worker side of the ledger, if we did nothing on the efficiency side of the ledger, the trend line is going up for a variety of reasons. We believe that it's the inefficiencies in the system that are driving the trend line up. The whole point of reform is to attack the inefficiencies there, save that money, and plow it back into benefits. If we can get that down, I believe that we can bring that trend line down, that we would go in the opposite direction of where we are on the natural going now. and that if we can bring more predictability into the system, we will drive down those inefficiencies and change that trend line. Looking at this graph, I just want to point out, in 2004, post-reform, the insurance companies made hand-over-fist profits. This was historically the lowest loss ratio ever in the workers' comp market. 2005, 31%. For every dollar the insurance company took, they only spent 31 cents in benefits. So I know that that's not the best answer for what's happening now, but the market is the wild, wild west. It is highly competitive. Because of the fraud that's in the system, it's an incredible way for employers to compete or to not compete fairly in the marketplace. And so we've got to be able to unpack what's happening in the insurance market. And I would like to posit in our discussions this year that we should look at a bottom line loss ratio, minimum loss ratio. What's good enough for the group health insurers should be good enough for the workers' comp insurers. That there should be a bottom minimum for how much they're paying out in benefits versus what they're collecting in premiums. We should have not a medical loss, I don't know what we would call it, but I'd like for that to be imposed into this discussion. If we're worried about insurance costs, then that invites more look and a brighter light into the insurance industry.
And I would concur with Angie. There's money in the system right now, and if we can work together to look at those efficiencies and the waste within the system, I think there's some real possibilities for positive outcome.
You know, I just do want to thank Mr. Chalk for your testimony, and I think as we saw from the charts from an earlier panel, you guys are doing a great job. You guys are really giving, I think, justice for injured workers and bringing a little bit more equity to the system. And I agree with you. If we look here at the other expenses element and the loss adjustment expense element, those are big chunks, and we need to better understand those figures and figure out how to reduce them so we can, bring more dollars to the injured worker.
Thank you very much. Thank you for your attention today.
Thank you. Any other questions? Our next panel is on Pay Your Perspectives on the Permanent Disability Rating Schedule. We have Carolyn Gino, Carlisle Brakenseek, and Tim Madden.
Thank you to the chairs and members of the committee for the opportunity to provide the medical community's kind of response to some of the discussions that have been had today. Clearly, this is a big issue for us, too. We're a fundamental part of the workers' compensation system, and there's kind of two fundamental points that I'd like to make today for the committee. First of all, California's physicians and the CMA does support the need to address the permanent disability issue in the state of California. In the time I've spent at CMA and talking to our member physicians who do workers' compensation work, they have all said, yes, since $8.99, those benefits have been too low and something needs to be done. Moving on beyond that, I think is where my second point comes in, and where we would urge caution for the legislature in using its discretion as to how to fund that. And I think we've heard a lot of discussions about the impacts of that today. While we do acknowledge an inequity with regard to permanent disability rates, we think it unwise to, if we're in a rush to address that, not fully consider the impacts of some of the decisions that we could make as far as things like fee schedules and other changes to the system that could negatively impact access to care for injured workers. Commissioner Jones did say earlier that the per unit medical costs or the charges for individual services rendered have remained relatively static. Conversely, billings of the number of services per claims and per injured worker have been increasing, but I think we need to point out that that's even while utilization review costs have been increasing as well. So if these processes and these requests for medical treatment are being approved, even concurrently with those increases in utilization review costs, we think it's difficult to really draw conclusions about the role of medical in some cases with regard to the costs in the system and where we go from there. As Mr. Swedlow said earlier, too, costs across the system are increasing. So it's not just medical, it's across the board. So, again, everything's tied together, and what we do going forward, any change impacts all other sectors of the system, potentially negatively. We don't have proof. One of the biggest things that's been discussed in recent years is a wholesale overhaul of the fee schedule and workers' compensation to utilize the Medicare system. One thing that we do want to point out, we don't have any hard proof that physicians in the workers' compensation system are overpaid right now. Then there isn't a justification to make the kinds of significant cuts to payments that have been proposed in some cases when we've been in discussions about using that Medicare system, the resource-based relative value system, for our official medical fee schedule. Just to be clear, that I'm not saying that the CMA or California's physicians flat out oppose the use of the Medicare system. We understand the benefits of it, the annual adjustments that are made to take into account practice costs, medical liability costs, et cetera. What we do oppose is the unmodified use of that system, so not making the proper adjustments to that fee schedule so that it responds to the workers' compensation system. Treating senior citizens is very, very different than treating injured workers. There's a lot of administrative work, a lot of legal involvement, we've heard about that today, that comes into play when we're dealing with injured workers, and the pay schedules need to reflect that. Otherwise, we can have attrition of physicians from the system, and that hurts workers, that hurts the system itself, drives up costs. We have worked actively in recent years with both chairs on your legislation, with Mr. Solorio on his compounding bill last year, with Mr. Liu on your lien measure, and there are other issues as well, the opioids issue, utilization review, and how do we address potential inefficiencies there. We would agree with Ms. Way that there are definitely inefficiencies in the system where funds can be found to potentially fund the increase that, again, we believe is warranted. But again, we would caution the legislature as to how to proceed and really taking into account those impacts. We want to continue to be a part of that discussion. We've been working with the division, with Director Baker, with Administrative Director Rosa Moran. We appreciate their time and want to continue to do that. So in closing, again, we support the need to address the permanent disability issue in California, but want to remain an active stakeholder in working with the legislature and other appropriate stakeholders to make sure we do it in a way that doesn't adversely impact access to care for injured workers. Thank you.
Good morning, Mr. Chairs. Carl Brackensick on behalf of the California Society of Industrial Medicine and Surgery. It's been a long morning, and so I will try not to replow these fields. I concur with what Carolyn had to say about the role of medicine in this entire process. It is significant. Touching very briefly, we spent a lot of time today discussing the AMA guides. The system we had before SB 899 was subject to criticism. It was claimed to be very subjective. There were a number of problems with it. But unfortunately, we ended up throwing the baby out with the bathwater with the adoption of the AMA guides. They specifically say in the first chapter of the AMA guides that they are not intended for use in measuring occupational disabilities. Yet the legislature went ahead and did that, and there have been many bumps in the road in implementing that system. We've seen repeated examples, particularly as Mr. Newhouser has pointed out, of dramatic reductions in permanent disability benefits for injured workers, and that is not good. That is not a good outcome. We do need to revisit that. We need to understand the important role that the cases of Almaraz Guzman and others play in bringing some modicum of fairness to the AMA guidelines, which are otherwise plain old cookie-cutter medicine. So it is important that we preserve the flexibility that has been fought and earned by the attorneys and the injured workers over the last 6 years to bring some fairness to the system, and we need to continue to work in that area. Carolyn mentioned the discussion of possibility of going to a Medicare-based fee schedule. That was not necessarily part of SB 899, but it plays a key role in this entire process, because not only going to an unmodified Medicare fee schedule would deprive injured workers of access to medical care by specialists, it would also impact the medical legal side of workers' compensation, because it would severely impair the ability of injured workers to prove their disability. They need, under the AMA guidelines, they are required to do a number of medical tests, which, if we adopt a Medicare-based fee schedule, will not be affordable. Doctors will not perform those services, and injured workers will be unable to prove their disability. This also will impact the employers because it will preclude employers from proving apportionment. So it's a very slippery slope. And even though Assemblyman Solorio, I know you were supportive of some form of an RBRVS system, it is fraught with dangers that need to be carefully considered before it is adopted in a wholesale business. Moving away from the AMA guides to other aspects of SB 899, one of the good things it did was to mandate the creation of the medical treatment utilization schedule. In earlier legislation, we adopted or mandated the ACOM guidelines, which cover less than half of occupational injuries. And most of their guidelines are consensus-based. They're not based on a high degree of scientific evidence. So we do have the medical treatment utilization schedule, which was adopted by the administrative director. That was a significant improvement, but it needs to go forward. We need to update that fee schedule. They have not tinkered with it for nearly a year now. It does need to be updated. Another change that was made by SB 899 was changing the panel QME process. Before 899, we had basically applicant QME exams and we had defense QME exams. SB 899 changed that process so that we basically have a single evaluator performing the evaluations. And the thought behind this was to reduce costs, to reduce the number of medical legal reports that were being written. What happened is that it has basically reduced the accountability of the physicians when they do their evaluations, and so we've seen a noticeable reduction in the quality of medical legal reports. So I would hope that when you do consider a consensus or a broad piece of legislation, that you would consider returning to the older system where we had basically partisan QME evaluations, where the doctors would have to write quality reports, well-reasoned reports, and they would have to stand up as substantial medical evidence, and you'd have much greater truth as far as coming up with a more accurate measure of the worker's disability. One of the big problems created by SB 899 that has been mentioned today was the authorization for employers to create medical provider networks. This legislation is totally one-sided. It is pro-employer, pro-insurer, very anti-injured worker, very anti-physician. Let me give you an example. Yesterday, I had a call from one of our members who told me that in order to join the First Comp Insurance, and I'm naming the insurance company now, First Comp Insurance, MPN, he was required to agree not to file a lien if there's a billing dispute. So, doctor, if you want to be in our MPN and treat our patients, you have to agree that if we have a billing dispute, you will not file a lien. Basically, our bill reviewer will tell you what we feel like paying, and that's all you're going to get paid. And if you object and file a lien, we're going to kick you out of our MPN. Now, that's not fair. That is a denial of the fundamental right to fairness. But this is how these MPNs are being abused. Another example, one of our members needed a neurological consult in Southern California. He contacted the MPN. They gave him a list of 62 neurologists that they claimed could do a neurological consult. He had his secretary call all 62 doctors, and not one of them would see an injured worker. They said, we don't understand why we're in this MPN. We don't treat injured workers. So here you had basically a bogus MPN. Given the number of complaints that I get on the phone, I think this is a fairly common problem. Now, I do say there are some MPNs that have been properly created. It appears, for example, Southern California Edison, Safeway, and a couple of others have done an outstanding job of putting together MPNs which do comply with the spirit of the law and are functioning adequately. But in my opinion, many, if not a majority, of the current MPNs are out of compliance with the current MPN legislation. One other comment that Mr. Chalk mentioned, and I will ratify here, is the restriction that SB 899 put on temporary disability benefits. They used to be basically open-ended, so as long as the injured worker was temporarily disabled and in receiving treatment, he or she could continue to receive TD benefits until they became permanent and stationary. SB 899 changed that basically to cut it off after 2 years. And so now we have a game that is being played where the insurance companies stall the injured workers, they delay treatment, they deny treatment, they go through all types of machinations to burn up that 2 years, and then they cut off the patient, cut off the injured worker, and starve them out. They force them, because they've taken away their temporary disability benefits, they force them into compromising and releasing their case for merely cents on the dollar. That is not fair. I urge you to consider reinstating the prior law so that we have TD for the full period of disability, or in the case of your legislation, at least some accommodation for serious cases. The lien problem, Senator Liu, we support your AB 863. It is a problem. It is probably more of a perception than a real problem. It does appear to be improving. The feedback I'm getting is that the problem in Los Angeles is not as great today as it was, say, 2 or 3 months ago. Some needs to be done. Your bill is a step in that direction, and we're certainly interested in working with you and the legislature to address that further. The one important thing that I've heard today from all the witnesses is the importance of everyone getting together and collaborating and realizing that if you make one little change somewhere, it may have an impact elsewhere within the system. That we all need to work together. All the interest groups are part of the problem, and all the interest groups need to be part of the solution to this problem, and we need to work together. Thank you very much.
Chairman Liu, Chairman Solario. Tim Madden, representing the California Occupational Medicine Physicians, and considering I'm the last person standing in front of you having lunch, I will make my comments brief and to the point. Our organization is comprised of 20 plus occupational clinics throughout California who treat over 75,000 injured workers on an annual basis. We are the front door for injured workers coming into the medical portion of the workers' comp system. There's been a lot of discussion around PD payments, so I won't go into any other points that have already been made. We do believe there are a number of areas to improve upon which could generate savings to the workers' comp system. Briefly, on the lien system, as previously discussed, this system is not working. One point that was made in the Commission on Health and Safety study on liens in 2011 was that a third of the liens were related to fee schedule issues. And we believe one way to address a portion of those is to move to RBRVS. We believe RBRVS better reflects the true value, the true cost of providing care. It'll provide for an updated and current fee schedule, which would help address a number of the liens mentioned in this report. Yes, this is controversial. We represent the primary treating physicians in the workers' comp world, and if we moved RBRVS in a budget-neutral fashion, it will lead to our folks getting an increase, and that increase would come from some of the other specialists in the system. The other folks in the system who would take a reduction have been saying that they would flee the system if this were to occur. And I would suggest to you all, as well as to the administration, that if that is the case, perhaps it'd be interesting to find out why they would leave the system. There are a number of these providers who are making anywhere from 300 to 500% of Medicare. So the question becomes, if someone's making 500% of Medicare and they get bumped down to 400%, are they really going to leave the system? The answer might be yes. It might be yes, but I think it's fair to ask what they're getting paid in other systems. There's also been discussion that RBRVS doesn't work, that other states are having problems with it. For the other states that have adopted RBRVS, they are still using it. Have there been problems? Yeah, they've been having problems. But they fix the problems, and for the most part, these systems are working. This actually can work to our benefit. We can learn from their mistakes. And I don't think anyone's suggesting that we move to an unmodified Medicare system. That is not the case at all. And no other state is doing that. But let's have a fair conversation on this topic. And I think the most important part in terms of RBRVS and the workers' comp system is what we're seeing from my clients is that they're starting to move out of the work comp system. They're moving into urgent care. Some of them moving back into primary care as those reimbursement rates are being improved at the federal level. And the impact of this is it might be a way to explain some of the comments made earlier in terms of Mr. Swedlow's comments on the unit price that we pay as well as the number of units. I'll wrap up my testimony by talking about some information that one of our clients received from a payer in terms of an analysis done of them treating injured workers as compared to other types of providers in the system. Briefly, what the figures show were that the average costs for an injured worker claim in our clinics was a third of what it would cost in a primary treating physician's office. The average duration of a claim, the average number of days the claimant was off work, as well as the average percentage of claims resulting in litigation was more than half of what it is at a primary treating facility. So I think the point here is that when you come into one of our clinics, you're dealing with folks that treat injured workers. That is our business model. We know how to do it. We know how to treat them. We know how to get them back to work in a quick and timely fashion when it's appropriate. As the reimbursement languishes around this, we're seeing more of those true Achmed providers leave the system. And this doesn't show up in the division's access studies because, for the most part, injured workers have access to care, but is it the right care? Is it being provided by the right provider? We would argue that it's not. We believe this is an interesting way of looking at moving to RBRVS to help keep some of these folks in the system. And this can help address some of, this potentially could be huge cost savings when you start looking at the difference between what type of provider is treating the injured worker. Really quickly on some other comments made, we would agree with Ms. Way's comments around the UR issue. For our folks who focus on injured workers entirely, we think there should be some relief in terms of not having to go through UR. Our folks are not getting denied at UR, but they are being held up unnecessarily. In terms of the MPN, we would agree that there could be some changes made to the MPN. If there are issues around the Palm Medical case, which Mr. McNally raised, we think those would be ripe for opportunity to be addressed in legislation moving forward. The idea of MPNs was really meant to pull folks like our members who are the best at treating injured workers and make that be the centerpiece of the MPN, not to just have it to be the Blue Cross network, which is what a number of payers have adopted. So based on that, and by the looks on your faces, I will stop, and thank you for your time.
Thank you. Any questions at all? Thank you for your testimony. I appreciate it. So before we open up for public comment, I just want to share with you some thoughts I had from today's hearing. So first of all, I support increasing permanent disability benefits. To me, the question is not do we increase them, it's to what level do we increase them? And I think we just have to be honest. And it may be that we cannot achieve enough cost savings to increase them to a level that would be adequate. If that is the case, then I think it's a matter of policy choices. The administration has to then, I think, alter its goal of saying we're not going to increase cost to employers, because we will. Or it's going to have to say, well, we just can't increase permanent disability benefits to the level we want to. But those are two different policy choices. But I think we just have to be honest about it, because the system today is not the same one as in 2005. It's changed. Costs just have increased for numerous numbers of reasons. If I could do something differently, I would go back and claw back the profits that insurance companies made in 2006, immediately after the reforms. Unfortunately, we can't do that. We're now in a place where it looks like insurance companies aren't actually making that much profit, and there are cities and counties that are, facing extreme problems with their own finances. And so these are policy choices we have to make, and I just want to sound a word of honesty and of caution. Having voted on 6 state budgets, I've never seen an optimistic financial assumption turn out to be true. I have seen the best and brightest minds on Wall Street take our country to near economic collapse. I've seen energy deregulation go completely berserk. This is a very complicated system. If any of you believe exactly what this system is going to do in 2 years, you are kidding yourself. And so I just want to make sure that we're honest and that we are cautious about what we do, which is why I believe my role is to deliver cost savings to the administration. And because an agency can react much more quickly than the legislature and can do things much more quickly, and they don't require, both votes in both houses, I would prefer to have administration determine what level they want to increase permanent disability benefits. And if they turn out to be wrong, they can change those. And so that's sort of my preferred approach. I think that would make the most sense given the extreme volatility in this market, given that we know this market actually collapsed before. We've had experience with it. And I commend all of you to read the book, The Black Swan by Nicholas Taleb. If you haven't done that, you really should. It's altered my way of thinking. I don't believe we actually will know what these reforms actually will do in terms of how much it will save. And so I just want to sound a word of caution and honesty. And with that, I'll turn to Chairman Solorio.
I primarily want to thank everybody for participating as panelists, because we did have a few and everybody gave excellent testimony. And I want to thank everybody that is still sitting here, because there's quite a number of you, and I do know that this meeting has been televised, and so I do appreciate everybody's involvement. I do want to say that I have an open door for anybody to come by my office and visit with myself and with my chief consultant, so we can better understand the points made today. And I'm one of those folks, I read the memos, I look at the data, and so I do really want to see all the data behind a lot of the statements made today, because it's going to be about transparency, it's going to be about facts, and I'm very committed to try to increase the benefits to those that are truly injured, truly permanently disabled. I'm not interested in seeing any more cost to employers. I do want to just see how we can find significant savings in the system to send over to the workers who I think really deserve them. And again, just want to thank you all, and look forward to a long year in terms of better understanding the complexity of this issue and some solutions to make it more efficient and beneficial to the injured worker. Thank you.
So we have public comment. Does anyone want to come up here and testify and keep us from going to lunch?
Late lunch.
I'm sorry, I shouldn't have said that. Apologize. We welcome public testimony. If you could please state your name for the record and who you represent.
Chairman Liu, Chairman Solorio, my name is Steve Katalik. I represent the California Society of Physical Medicine and Rehabilitation and other healthcare providers. I applaud what Angie Way had to say with regard to what she called inefficiencies. My background is not just as a legislative advocate for physician interests, but I spent a vast part of a 20-year career in managed care. I was the guy they loved to hate. I sold bill review, I sold utilization review, I sold network. I know how all that works. And her point that 84 cents of every premium dollar was really only going to benefits, notwithstanding the question about benefits actually being greater than premium. I think that it just only points out that there is a vast amount of information that you as policymakers need to uncover. You need to be inquirers. I'm sorry that you have to understand this industry the way that you're going to need to understand it to make the decisions the best you can. It's arcane. It will put you to sleep if it hasn't before. But nonetheless, you've heard from a number of people today. You've heard that they all have good points, but none of them, including me, should be believed on their face. There isn't a study. There is not a commission. There's not an organization that does research that will be the definitive answer in any way. The amount of inquiry that needs to be done, and as Mr. Brackensick pointed out, the number of stakeholders that need to be involved in any what might have been called a grand compromise, if it's that grand, I would be suspicious. It's not that simple, as you pointed out. So I would only suggest, and I would urge, that this not be a end of session, quick move, but that it be a studied inquiry over a lot of time. And I don't mean to draw it out. Injured workers need help.
Our members deal with them every day, so I don't mean to say that. But by the same token, what happened with the PD rating schedule is that an agenda got filled in the late of the night by too few people making too big a decision. I applaud both committees and your past work getting to the details, starting that inquiry, but please don't stop. And I would also urge that as legislators in your own districts, that you urge your own staff and your colleagues' staff to attend those listening tour. Please don't take anybody's digest version of what happened. Have somebody in your own staff attend. I don't think that Mr. Baum and Mr. Rakich would necessarily be the best people, but somebody from your staffs need to be at every one. Do you want to go? Well, there's 11 or 12, Gideon. Suffice to say, don't take anybody's word for it, including mine. Take your time and include as many people as possible, because there is no grand compromise possible. As you've already pointed out, there's just way too many moving parts. Thank you.
Thank you. Go ahead.
Yes, my name is Teresa Abbas. I represent Voters Injured at Work. I'm the operations manager. And Chairman Liu, I would just like to say that lots of facts and figures have been, statistics and things have been presented here, but what you may not be seeing are the injured workers. And those are the people we advocate and educate every day. A lot of the people that are calling our office are calling, they don't speak English, so we deal with a lot of monolingual Spanish speakers who don't understand the system, and they're sort of getting left by the wayside. They have no way of making a living. So what we're hearing are horror stories like the one that Ms. Wei commented on earlier. And these get worse and worse, where sometimes people lose everything. They lose their homes, they lose their cars, lose their families because of the emotional and psychological impact. And I just want to urge you to, along with looking at the facts, figures, and statistics, to think of all of the injured workers and how any of these changes are going to impact them on a small scale and on a large scale. And that is all.
Thank you.
Thank you for the opportunity. My name is Ernesto Barreto. I represent Latino Comp, an advocacy group for injured workers, but also a group that has become increasingly cognizant of the disproportionate negative impact of SB 899. I also represent injured workers as an applicant attorney. This April 19th will mark 8 years that I have seen injured workers either lose their home, lose their families, or lose their dignity because they're unable to go back to work because of their injury. We really need your help. Please, please turn an ear to the injured workers' plight, because we really need your help. Thank you.
Thank you.
Yes, my name is Lorena Cacciatore, and I am one of those injured workers. In May of 2009, I worked for a nonprofit agency, Mental Health, and returning from a field-based appointment, I had a car accident. A car hit me from behind, and I reported this accident to my human resources, and I was sent to our doctors from our insurance, which took months and months of me in pain, getting appointments, setting up, almost 6 months until I was given an MRI, and they found 2 tears in my shoulders. It took a year of trying to, the MRI, when they found that I had the injury, it took another year for me to have my first surgery. I was out for a year. I returned to work because I am a single mother of 3, and I lost mostly everything, all my insurance. I could not pay COBRA. I returned to work, and after 9 months of working there, in November, I was approved for my second surgery. And my agency, after working 6 years with them, fired me. And now, since they had approved it, now we're in trial. It's taken months. They won't authorize medication. They won't authorize my surgery. Now it was I saw a QME, saw me for 20 minutes, had never seen me before, was very hostile and rude, telling me, come on, you can move your shoulder, my left injured shoulder, when I just had surgery. So I am one of those people that I have been very emotional for me to come up here and to witness this and to see there's so many other people like myself that you would take in consideration that, yes, the insurance companies, I have seen with the healthcare providers how they have just continually wasted money sending me chiropractic, sending me to acupuncturist, sending me, instead of having my surgery, which they had proof with the MRIs. So I ask you, I am one of those. I lost my house, I lost my family, I lost my job, and now I am at the hands of what the judge, I will be going to trial and still not being approved for my second surgery and not able to work and losing my job. I'm not able to have any benefits. So I had to go on unemployment. So from a salary of almost $50,000 to getting maybe not even $1,800 a month. So that's where I am. So there's many more. I'm not the only one. So I ask you, and I'm happy that I was able to state what has happened to me. And I know there's many, many more. This is happening.
Thank you. Thank you for sharing.
My name is John Larson. First off, I'd like to start off by supporting pretty much everything that Ms. Way had to say today. It seemed accurate from what I've seen. I've treated injured workers now for several years. I work closely with VIAW, Voters Injured at Work. I've seen this gal's experience day in and day out in our clinics. It's unfortunate that our injured workers have to go through this situation. There certainly is no upside for anybody to claim an injury at work at this point. Like she said, dignity is out the window, family, hope, their future pretty much is washed down the drain once they file that claim. You want to see the increase in costs? She exemplifies that. Can you imagine how many times the defense attorney has had to appear or send a ridiculous letter, wasting time, billing hourly to make that happen, to drag this out? Her TTD likely is exhausted. On a case that is clear-cut, objective findings on an MRI that should have had a surgery within weeks. Instead, she's years into the system. Likely, if the PD system was correctly set up, that rating now, because she's drug along for so long and become so chronic, is going to be much higher than it ought to have been had she had that surgery timely. I think as doctors, as providers, we've been forced to make cuts, to become more efficient with all of the changes that have come in with fee schedule, compounding, whatever it may be. We've learned how to live more lean. I think we need to ask the insurance carriers to do the same. When you have defense firms that are billing hourly on these charts, taking us to court day in and day out, billing exorbitant amounts for a ridiculous letter of objection where it's all a form fill. I mean, the answer is right there. Get these cases moving. My next question is, why were the MPNs created? Were they created to create unreasonable profits for insurance carriers, or were they created to streamline and make the system more efficient, provide qualified providers for injured workers? Was it to streamline the system? Because what we see now is doctors, other than what he had mentioned with the first comp deal, which is the doctors having to sign off on his ability to collect money that may be reasonable to him, but they're also having to sign that they're going to take reduced money below fee schedule. The fee schedule was created, wrong or right, to pay doctors for their work. If you keep reducing those costs or the money available to the providers, they will leave the system. When HMO work becomes more palatable than writing a 20-page narrative for work comp, knowing that I won't receive my money for 3 to 5 years on that report, trust me, HMO looks much better. The fellow who sat here discussing his clinics, I asked that individual how many reports is an attorney, an applicant attorney like Ernesto Barreto, is he going to be able to settle on? Because they don't create those kind of reports. If the treatment was solid there, they would never show up to an applicant attorney's office. They would never show up to our offices. The treatment is less than thorough. If it was, they would never have left. There would never be that situation where they would need an attorney. You ask, or you've mentioned several times, Mr. Solario, why the ratings, or you've mentioned the ratings are much higher when they're represented. Well, there's a big difference. When they're unrepresented, they stay with, excuse my language, the hack doctors the insurance companies have placed on their panels. You recall, the labor code allows them to economically profile the doctors they keep in their MPNs. With that being said, if the doctor can do the treatment for $5 as opposed to the $10, that $10 doctor's out. The minute the $2 doctor shows up, the $5 doctor's out. And that results in poor quality of care. Now, what happens, they get frustrated, they end up with an attorney. They get the attorney, depending on where he's at with his knowledge base, he may challenge whether or not they should or should not be within the medical provider network. Once they move them out, now they're able to get them reasonable treatment. Now, those doctors likely will now have to work on lean. When they're working on lean, these individuals, you wonder how we can afford or not afford. Likely the individuals representing those clinics is getting paid in real time. The doctors working on lean are 3 to 5 years out, stuck in a basement in Southern California somewhere. That's unfortunate. The reason those applicant doctors are able to get that better result is because they have more comprehensive reporting available to them. And that's why you're seeing that happen. Whether or not AMA Guides is wrong or right, there is a financial cost driver or financial incentive for the doctors within the MPNs to cater to the hand that's feeding them. They're going to continue to produce low ratings. When you ask to add on the psychological component that this lady is now undergoing, they will deny you as that doctor. They will remove you once you make that referral. They will kick you out of the MPN. The doctors aren't allowed to treat the patients the way they ought to be. I think you can exist as an industrial medicine doctor, provide good care, and not have the system be abused. But I think we have to push aside some of the abuses that the carrier is putting us through right now. There are inefficiencies. Their cost drivers are through the roof. Utilization review is a joke, an absolute joke. I've met with utilization review doctors, and everybody realizes, hey, I've got to deny some, and I've got to admit some. I've got to keep my job. I mean, is that really what you want your mother to go through? Some guy who's just trying to keep his job, or do you want effective care and effective reporting so we can get these cases moved? All in all, like I said, I support Ms. Way. I've had the chance to speak with Ms. Moran, and I'm excited to see that we might be able to have an effective communication making these changes moving forward.
Thank you.
Thank you.
Go ahead.
I'm Jeremy Mers. On behalf of the California Chamber of Commerce, we appreciate the chairs holding this joint informational hearing, and Christine Baker, and she's still here, and the DIR holding the public forums throughout the state to address issues with the workers' compensation system. The Chamber agrees with the sentiments expressed by many panelists today that any augmentation of benefits needs to be more than offset by cost savings, and we appreciate Chairman Solorio and Chairman Liu's efforts to this end. California is one of the most expensive workers' compensation systems in the country. The reason why can be disputed and will no doubt be subject to debate. Suffice to say, the system is as expensive as it is complex. The Chamber looks forward to being a constructive partner along with labor, the legislature, and the administration in finding viable, balanced, and sustainable solutions. Thank you.
Thank you.
Thank you, Mr. Chairs. It's good to be here. Jason Schmelzer with the California Coalition on Workers' Compensation. Senator Liu, you asked for honest and cautious, and I'll start with honest, and then maybe I'll just abandon cautious altogether. I find it striking that the people that maybe did the most complaining today are people that depend on the system for a paycheck, as opposed to the people that pay for the system or rely on the system to fix their injury. I find that striking, and it's going to become a theme over the rest of the year. People are going to be defending their territory in this system, their piece of the $15 billion. And what it really comes down to for you when you're trying to figure out what to do is that no category of stakeholder in this system is innocent 100% of the way, right? Employers broadly try to do the right thing. The vast majority. They try to treat their workers right. They try to follow the law. They don't cheat on their premiums. But then you've got this small percentage that cheats, that treats their workers bad, that drives costs for the rest of employers. Okay, their small 5% is way more expensive than it should be. for the doctors. Most of these people got into the profession for the right reasons and spend their days doing the right thing. They want to fix people. They want to help people get back to work and on with their lives. But there is no doubt that there are some that try to take more than their share. It's been repackaging, it's been compounds, now it's spinal surgery. You've got people that give spinal surgeries to people with carpal tunnel syndrome. You've seen the examples coming out of Long Beach Hospital. That's disgusting behavior, and it needs to stop. That small percentage of physicians causes a huge expense on the system. It's a small percentage. For the attorneys, most of them, exactly the same as the doctors, join the system for the right reason. They want to help people move on with their lives. They want to help them get what's owed. But there are some of them that intentionally complicate the system and game the system in order to get a hold of benefits that aren't deserved and for their own financial benefit. We need to figure out how to stop those folks from doing that. Again, it's a very small percentage, but it's a very expensive percentage. The same is true with claims administrators. For the most part, I used to administer claims. I'm sure I've told you that 150 times by now. But there were those of us that did our best to do what was right. It's an incredibly complicated system. But you've got some jaded folks out there who don't, and they have gotcha tactics, and they do things that are wrong. Those people cause problems in the system that then turn around and cost the rest of us a lot of money and time. And then vendors. You've got your mom and pop shops that do copy service and interpretations and invoke experts, and they're trying to do the right things. They're trying to meet a need in the system. But then there's that small percentage, right? The ones that realize that there's no fee schedule for Evoke reports, and they charge outrageous fees, and the copy services that realize that they don't just need to meet the needs of the applicant attorney that sent them to the insurer. Maybe they can do all of these other things and send the bill to the employer, and it'll just get paid, even though the applicant's attorney didn't even ask for it. There's a problem. There's this 5%. And when you're looking at how do we go and pay for injured workers' benefits, there's $5 billion sitting in the expense category, over $5 billion. There's money there to both pay for those benefits and to reduce costs for employers to get ahead of that kind of curve that you were talking about. We just have to have the strength to do what's right.
Thank you.
Good afternoon. Ignacio Hernandez. I originally came here on behalf of voters injured at work. We heard from the workers already. I just want to add a couple of comments as a private citizen and in my capacity as a former attorney, or I'm still an attorney, but I've worked on some cases, and point out one issue that going forward we should either address or discuss or keep in mind as we're trying to craft a resolution. I actually wasn't intending to speak today, but I do want to raise some of the one other issue that workers are going through that is a little bit outside of here, but is directly created by the challenges that we're facing. Give you an example of a worker whose job was to dislodge tires from rims of garbage trucks. Okay, very manually intense job. Tore his rotator cuff. Really no question that it was work-related injury. When he went through the process, he was asked at the outset by a claims adjuster, history of injuries. Okay, we all in this room have some understanding of apportionment. Unfortunately, he's around 60, native Spanish speaker, not a real clear understanding of apportionment, rattled off some injuries, and forgot to mention that he strained his back and strained his arm when he was a janitor breaking up a fight 23 years prior. No rotator cuff injury, nothing else. Came up later on, and the insurance company prepared a memo and sent it to the district attorney, even though his case was open. 2 felonies. He was charged with 2 felonies for insurance fraud. And it's the general insurance fraud statute that was used. It's not narrow to apportionment. It's a very low threshold to show fraud. And his case was open, so it could have simply just been adjusted. His overpayment was $50. He could have simply paid the $50. Let them adjust the apportionment and let the case continue. The insurance company refused to do that, insisted that he pay back their legal fees, which they're entitled to under the penal code, or under the criminal code that was used, of $15,000 for preparing the memo to be sent to the DA. They said they'll push to drop the case if he dropped his workers' comp claim. I've been seeing these types of cases more and more because workers can have no way of knowing all of the intricacies of the workers' comp system. And when they're faced with making some minor mistakes on apportionment in particular, they're liable to fall down this hole and not get out. And it's a way to save a way that saved money for insurance. If we had, I know you used to be chair of public safety, so you understand. There's not a statute specifically on apportionment, or to make clear what that means, to make clear that somehow the worker has a high level of knowledge of what that means. When he was asked by the district attorney investigator about this injury, they brought it up and said, well, weren't you injured 23 years ago? And he said, oh, I forgot about that. He goes, but I'm not sure what that has to do with my rotator cuff injury that, when I was pulling it off. They said, well, you didn't tell the truth. And that was it.
So omission.
Exactly. 2 felonies he was looking at, and that's here in Sacramento County. There are a number of other cases like this, so I think we have to keep in mind, even though we have a broad scope that we're looking at, that there are still some other issues that are byproducts of this problem, and I look forward to talking to you about that going forward.
Did the DA charge those?
Yes, charge both for a felony for false statement to the claims adjuster, and also for a false statement for perjury during deposition.
Okay. Thank you. Any other public comment? Thank you very much.